Can you hear me?
Oh, we're just.
Right, okay.
Okay, I got it. Wait, let me turn it back on. I just pressed the no need quick switch. So if they try to say anything to you, just tell them that you guys want to check the official booking schedule.
Oh no, they didn't say anything. We are good.
No, but because they'll probably continue. Just so you know.
Yeah.
And you could tell them that you we just took it off. Because we don't have to kick you guys out.
Yeah. Hold on, don't do anything. Don't do anything right now.
No, because we already tried.
Oh, this one doesn't work.
Yeah,
okay, let me just use the TV one.
We just tested it. No, it's working.
Oh, fuck.
What is?
Wait.
Oh, hold on.
By the way, for your information, I still have the extra wires and that camcorder thingy. Yeah, so if y'all need it, just let me know.
Okay, that's fine. Just do
That's
another
fine.
test.
It's fine.
Just test the microphone. You
My
can
lap-
yourself there, right?
Yeah,
Also, my laptop is outside on the left. If you want to use my laptop, you use
Okay,
it.
using.
Okay.
Can you check?
Oh yeah, you're.
Timer.
Yeah, Samantha, I can hear you.
You click on me. Okay.
Okay.
Hi, can you hear us?
Yep.
Okay, perfect.
You guys, I'm ready when you are.
I'm ready.
So you guys, how do I refer to you? Is it Counsel?
Oh,
Yeah,
so
you can call me us counsel, but I'm Brandon and this is Mark.
Right, okay.
counsel and co-counsel, you can just
Yeah,
use anything.
you can just interrupt and say counsel.
Okay.
And so we're appellants. We'll speak first for total 20 minutes, split 10 minutes each on all the issues. And then respondents will address all the issues in 20 minutes as well, split 10 minutes. And then 1 minute for rebuttals and surrebuttals.
Okay. 1
And
minute
would you-
each per
Yeah,
each
for
1
person.
minute each.
Oh, each team. Each team.
Oh, each person.
Each person. Okay.
Each person. So
on rebuttal.
Yeah,
On
so
rebuttal, just 1 minute.
Yeah. So do you want to do rebuttal together, like for 2 minutes, or?
It's up to you. What?
I think doing when it comes to rebuttal, we'll get back to you guys again.
Can.
But for now, I think
It's each team 1 minute.
Each team 1 minute.
Oh, okay.
each team 1 minute.
Yeah, just a short one. And can we just clarify who is the
President.
Madam President?
Apparently that's me.
Yeah.
Just
Okay.
who is it?
Samantha.
yes.
Is going to be the Madam President,
Okay.
and some
Can you
wise.
hear us well, by the way?
Say again?
Can you hear us clearly?
Yes.
Yes, we can.
Okay. That's good.
Okay. And before I start recording, would you guys like a summary of the facts?
That would be great. It's so
Yeah.
long. We try to read as much as
I have no
possible.
problem. Okay, so just briefly here, the appellant, Mr. Antonio Fortuna, who's my client, is the goalkeeper of the Iridonian men's national team who played in the 2026 FIFA World Cup qualifiers. And after they lost 0-3 to Cometland, a betting report prompted the respondent, FIFA, to open disciplinary investigations on my client. And as a result of that, witness statements alleging possible match fixing by the appellant and father, and then the Iridonian public prosecutors also began criminal investigations. And during the investigation process, my client refused to provide his mobile phone. And as a result of that, FIFA sanctioned him for 5 years and gave him a 100,000 Swiss franc fine. And now we are bringing the appeal to CAS.
Okay.
Good afternoon, Madam President and member of the panel. My name is Brandon Zhang, and together with my co-counsel Mark, we represent the appellant, Mr. Antonio, in the proceedings. Members of the panel, the appellant has devoted his entire life to football. A late bloomer by reputation, he trained relentlessly to earn the honor of representing Iridonia in its 2026 FIFA World Cup qualifier, a moment of immense national pride. And now he stands before the panel seeking nothing but fairness. His statement of appeal was filed within time, and a technical failure beyond his control should not deprive him of access to justice. And when confronted with an ongoing state criminal investigation, his refusal to surrender the mobile phone was a lawful step to protect his rights and avoid self-incrimination. The sanctions imposed were unjust and disproportionate to the realities he faced. I now turn to the first submission. It is our submission that the statement of appeal is admissible for 3 reasons. First, the day of receipt is 2nd April 2026 because the challenge decision was sent to the party with grounds and therefore falls within the 21-day timeline. And second, the appeal was only late due to an IT cyber attack, which my client had no control over. And third, we have submitted Exhibit 8, which proves that we have in fact filed the statement of appeal prior to the deadline. On to the first argument, Rule 58 of the CAS Code provides that the panel shall decide the dispute according to the country which the association or sports-related body has issued the challenge decision. And therefore, pursuant to Article 15, subsection 1 of the FIFA statutes, the appeal shall be lodged with CAS within 21 days of receipt. And read together with Article 15, subsection 2 and 4 of the FIFA procedural code, notification is deemed to be complete whenever there is a sanction. It has to be communicated to the player with full grounds. And in our legal authority number 1 in the CAS decision of Ivan Bellotto, Palacios versus PFC versus CSKA Sofia, the panel held at paragraph 75 that the statement of appeal was admissible because that was the day where the grounds with decision was communicated to the player, and that day was the day of receipt. And accordingly, they held that it was admissible. And this is precisely the situation with our case. If I may now direct the panel's attention to paragraph 26 on page 5 of the record. Is the panel with me? Here, the challenge decision was sent to the parties with grounds on 2nd April. And below at paragraph 27, it states on 23rd April, the appellant paid a filing fee and filed the statement of appeal. And therefore, the appeal was filed within the 21-day timeline pursuant to Article R32 of the CAS Code, which expressly provides that the time is respected if communication is sent before midnight on the day of the deadline, which is precisely what is the case in our situation here.
So may I clarify, the time of receipt is the time of sending or the time of when they first open the email?
It is the time when the appellant has the opportunity to open the email, but the dispute here arises because the respondent is challenging the day of receipt because they say that just a simple decision enough. But according to Article 15(2) and 4 of FIFA procedural rules, notification is only deemed complete when decision with grounds is communicated. And that was the case at paragraph 26 of the record. Turning now to the second argument. The statement of appeal was only late due to an unforeseeable IT cyber attack, which my client had no control over. I would like to introduce the panel to the 2013 cast decision of AC Siena SPA versus Club Desportivo at paragraph 39. The panel held that the statement of appeal was timely filed when the appellant produced a shipping way bill to prove that the courier company picked up the shipment on the day, and that's why it was late. And therefore, in our case, due to the IT cyber attack, that's why the statement of appeal was late. And we have submitted Exhibit 7, which is at page 531 of the record, to show that the email was in fact sent out at 23:45 Eridonian time. And therefore, we ask that the panel allow and hold that the statement of appeal was filed on time. If there are no further questions, I will turn to submission 2. Members of the panel and Madam President, in our legal authority number 4, in the cast decision of Jerome Valk versus FIFA at paragraph 266, the panel stated, in regard to invoking the privilege of self-incrimination, I quote, "The danger is that the result may point to a later criminal proceeding is not valid to invoke the privilege. However, where there are concurrent disciplinary and criminal proceedings, this appears debatable." And this is because there's a real danger that the FIFA could share information with the Eridonian public authorities. And therefore, my client is at risk to incriminate himself in the criminal proceedings.
Sorry, counsel, your position or your client's position is that there was no match manipulation, correct?
Yes, that's correct.
So what then would incriminate your client on his phone?
Yes, member of the panel, there is in fact no conclusive evidence on the facts to even argue that my client is guilty of match fixing. All the evidence is purely circumstantial.
Oh, so if the evidence is circumstantial, then what on his phone would incriminate him?
Yeah. Like what
Yes.
does he have to fear?
This is particularly because my client has a right under Article 6 of the ECHR, which is a right to a fair trial. And in the proceedings, my client did not have a fair trial because they simply imposed a sanction upon my client's refusal. He didn't have a chance to have a fair trial. And we find support in this in the cast decision of Amos Adamu versus FIFA at paragraph 66, where the panel said that Article 6, subsection 1 of the ECHR are indirectly applicable even before an arbitral tribunal, all the more so in disciplinary matters, because the Swiss Confederation, as a contracting party to the ECHR, must ensure that its judges checking arbitral awards verify that parties to an arbitration are guaranteed a fair proceeding. And it is our submission that my client has not had a right to a fair trial / proceeding in these circumstances.
So the test for a fair trial, does that involve the process of evidence? Because wouldn't you agree that a fair trial can only be conducted with sufficient evidence?
Yeah, the applicable standard of proof pursuant to Article 39, subsection 2 of the FIFA disciplinary code is that of merely comfortable satisfaction. But even so, as my co-counsel will address the merits in regards to evidence, there is still not conclusive evidence, and the respondent relies on the sports betting market analysis. And the betting report only gives evidence to the match as a whole, but does not pinpoint to one player. Specifically, it does not pinpoint to my client or any of his actions during the match, which proves that he was involved. And then all the other evidence on the facts does not establish an actual link between my client and my client's father. And moreover, as my co-counsel will explain furthermore, my client was sick on the day, and this is reflected at Exhibit 6 in his witness statement. He was sick the day before the match and consulted the team's doctor. However, being that it was once in a lifetime opportunity to represent his country, he decided therefore to still play in the game. And therefore, any performance could be excused by his illness.
Can I clarify? You said that Fortuna, the game analysis didn't show that he's the one that was particularly poorly performed, right?
Yes.
But the thing is, his name appears in page 8 and 9, page 8 and 9 multiple times in the analysis. Wait, sorry. What page is this? This is the goals description, the time score,
Okay.
performance analysis, right?
Yes, Madam President. I note your concern here. As mentioned earlier, sporting performance has its ups and downs, and particularly in this match, he's described as a late bloomer, as he was recently made onto the team 2 years ago. And because there was immense pressure as the qualifier game to the World Cup, this poor performance can be explained by two reasons. First, he was sick during the match, and secondly, there was extreme pressure, and he was also a replacement goalkeeper in the match. He was selected purely as the replacement goalkeeper because the starter goalkeeper was injured, and that's reflected at page 3 of the record. If there are no further questions, this brings me to the end of my submissions. I now hand the time to my co-counsel.
Good afternoon, Madam President and Miss Arbitrator. My name is Mark, and I'll be speaking for 10 minutes, and I'll be reserving 1 minute for rebuttal. I'll be tackling the issue C and issue D in my oral submissions. My issue C will first go through if the CAS strictly applies safeguards. First, the CAS applies strict safeguards to the anonymous evidence. Second, those safeguards are not met for either the witness or the email evidence. And third, without them, the evidence cannot reach comfortable satisfaction. The CAS starts with the position of distrust when it comes to anonymous evidence. In the 2019 CAS case of Karamuddin and FIFA, the panel made it clear that anonymity is exceptional and not normal. It is only tolerated when 4 safeguards exist, which are necessity, verification of identity by the panel, the ability to test the evidence through protective cross-examination, and corroboration. Those safeguards exist to protect one thing, which is fairness, and none of them exist over here. Let us look at the witness itself. The witness says that they're afraid not because of anything that happened, but because of the rumors that the appellant's father is a part of the mafia. In Karamuddin at paragraph 145 to 149, anonymity was justified because an objective third party confirmed a real risk. A co-witness had been granted asylum. Here, we have nothing of such sort. No police assessment, no independent confirmation, just rumors. And unlike Karamuddin, there was no attempt at protective cross-examination, no audio scrambling, no visual screening. The defense was never allowed to test the witness as seen on Exhibit 2, paragraph 5 and 6. Now, I would like to talk about the observation itself. What did the witness actually observe over here? He says that he saw Mr. Fortuna stressed the night before the match. He hears him saying, "Dad, stop pressuring me." But critically, the witness admits that he never hears what the father says, as seen on Exhibit 2, paragraph 8 to 9. In the 2009 CS case of Pobeda, at paragraph 69 to 73, it was held that if the evidence is missing its context and the evidence cannot meaningfully be tested or cannot satisfy the standard of proof. Just because he was stressed doesn't mean he manipulated the match. As an athlete myself, I have experienced stress before match because it's human nature. And it's human nature to mull over such things. And I express those feelings to my loved ones, such as my family and friends. But that doesn't mean that I'm manipulating the match. I'm just sharing my deep concerns about the match itself.
Sorry,
Now,
Counsel. What's your client's position? Is your client saying that this phone call did or did not happen?
This phone call happened, but it was not about manipulation, Madam Arbitrator. It was just
Sure.
that
So
my client.
are you contesting the truth of anything in the witness statement?
We
Or
are
are you just saying
contesting
it's out of context?
it out of context, madam, because we do not know what the father on the other side said. The witness only claims that he heard Mr. Fortuna mentioning that he is stressed and stop pressuring me. For all we know, the father could be saying that. Mr. Fortuna could be saying that, "Father, I don't want to compete. I'm scared. I'm worried that I will let my country down. This is the first time our nation is competing in a FIFA competition."
So
And
does
the
your
father,
client admit to the exact words?
sorry, Madam Arbitrator, could
Like
you repeat that
in
question again?
paragraph 9,
Mm-hmm.
that he simply could not go along with him in everything. Does your client agree to that witness statement?
May I also check?
Yes,
Since
Madam
this
Arbitrator.
there's this anonymous witness statement, which I believe your client would have had a chance to review.
Yes, madam.
Why did he not address the rumors that his father was involved with criminal organizations as well? If his
Madam
father
President,
was not, yeah.
Madam President, he did not address the rumors because he firmly believes that his father is not part of the mafia, and it is not something to be brought upon if something is not relatable.
Then
He
couldn't
also
state it from the start to disprove the honesty of
he,
the witness?
he also mentions on page 16, paragraph 18, that I have no knowledge of the transfer by the transfer received by my father on dodgy coins, the 50,000 dodgy coins. So, Madam President, he had no idea what his father was doing behind his back. All we are claiming that the athlete, Mr. Fortuna, did not manipulate anything, and he did not foresee what his father could do or would be doing at the present time. All we know is that we are talking about my client, the athlete, and he did not corroborate nor he manipulated the match itself.
Then going back to Madam Arbitrator's question on
Yes,
whether
Madam
or not,
Arbitrator. Madam Arbitrator, I apologize, but could you please repeat the question again?
Basically, does your client admit to the facts of the phone call, albeit out of context? Did what happened in the phone call happen?
Yes, Madam Arbitrator. My client accepts the fact that the phone call did happen, but we contest that the conversation which took place is was taken out of proportions.
then,
As seen on Exhibit 2, Mr. Fortuna as Mr. Fortuna, Exhibit 2, paragraph 9, it is said that Mr. Fortuna was telling his father to stop pressuring him, shouting that he simply couldn't go along with everything. However, I could not hear what the father was telling him. So while we are hearing the side of what Mr. Fortuna is saying, we do not know what the father is talking about.
can I
So
ask what is the burden of proof for the athlete here to show that his conduct is not that he did not manipulate the match. What is the burden of proof?
Madam President, the burden of proof is comfortable satisfaction. Here, we are not meeting the requirements of comfortable satisfaction.
What exactly is comfortable satisfaction?
Comfortable. Madam President, the comfortable satisfaction criterion is less than criminal and more than balance of probabilities. Madam President, as I understand that I only have 3 minutes left, may I ask for an extension of 5 minutes to, 2 minutes to wrap my both arguments. Thank you. So moving on to the second submission, which is issue D. We would like to put forward an argument that the appellant submits that Article 20 of the FIFA Disciplinary Code has not been violated. First, the match fixing must be proven of the high standard of comfortable satisfaction. Second, the Genius report raises suspicion, but it does not attribute manipulation to Mr. Fortuna. And lastly, there is no evidentiary breach showing either manipulation under Article 20, subsection 1, or a reportable approach under Article 20, subsection 3. Now, I would like to move on to the Genius report itself. FIFA cases rely heavily on the Genius report, but the Genius report is merely an opinion. It flags suspicion. It does not accuse individuals. On betting, there is no evidence that Mr. Fortuna placed bets, facilitated bets, or even communicated with any syndicate. It's a measuring gauge for only the performance. The report highlights errors, but errors alone has never been enough for the CAS in the CS jurisprudence. It is to be noted that the Iridonian dominated the early statistics. Possession was high, shots were even higher. The decline came only later when fatigue and physical conditions started to kick in and not design. Mr. Fortuna was already sick at the time, and he had also highlighted to the team doctor as seen on Exhibit 6, paragraph 9 to 10. It is important to note that we know what genuine manipulation is inferred from an on-field conduct, because there has been many cases in the CS jurisprudence, and one of those cases is the CS case of Asian Handball Federation and International Handball versus International Handball Federation. Here, the panel found that officials were effectively inventing decisions. The pattern was so excessive and one-sided that it could not be incompetence, but bias and intention, as seen on paragraph 74. Crucially, the referee was even changed mid-match, showing the referees could perform properly when they wanted to. Unlike the Asian Handball Federation case, Mr. Fortuna had no structural or decision-making control over the match. He was a mere replacement goalkeeper. And
So
even
do you need structural control over the match to manipulate it?
I would think that especially for a goalkeeper, you would have a lot of control over how the game continues, right?
Madam President and Madam Arbitrator, while I'm putting forward the argument that you need a structural control over the program, we are forgetting that Mr. Fortuna is also a replacement goalkeeper, and he lacks the skills of being a good goalkeeper, and that is why he was going through such a tumultuous period, that he just couldn't get himself up to the game and tried his best to represent the country in the FIFA qualification round. And the Genius report also does not say that the 0-3 loss was Mr. Fortuna's goal. He was under pressure. As recorded in the performance analysis, the goal section at 64 minutes and 4 seconds, it is expressly stated that the second goal involved no individual error. So it was not due to Mr. Fortuna's manipulation or any negligence.
So
And
may I
at 80,
clarify?
yes, Madam President.
Your stand here is that match fixing has occurred? And
No,
that
Madam President. We are trying to put forward an argument that Mr. Fortuna is just an average player who should not have been competing on a FIFA level competition.
Then I would
Yes,
like to
ma'am.
state that there's a lot of coincidence in the facts I mean, firstly, the Comet, the other team, Comet Land, had
Mhm.
even the betting stage. They were favored and had they were abnormally favored pre-match and during the start of the match as well. And this was seen like after your client received a suspicious phone call from your dad, which he didn't clarify what the context of the phone call was.
Mhm.
You're merely speculating that it could be on other things. And after which he had poor performance and he claimed to be ill. All of this just creates a very a narrative that goes against what your client is claiming.
Yes, Madam President, I understand that it creates a mosaic of evidence which incriminates my client, but we would like to highlight that the circumstantial evidence does not mean that Mr. Fortuna, my client, was manipulating the match itself. We can see that the Genius report itself clearly states that none of the goals which were made were due to his own error. At 88 minutes as well, the third goal resulted from his teammate's hamstring injury, but the report again confirms it was not a performance error. So while the picture which is painted against Mr. Fortuna, my client, we also have to look at the different angles of this case itself, which is that while things were going in a way where it would incriminate my client, if we also have to give him the chance to defend himself and say that this all could be happening on a fluke. For all we know that this could be happening right now in the current FIFA competition match right now. But it's just so, but right now, just because of the whole story, we are not able to fathom it. And even the Genius report says that it was not Mr. Fortuna who was consistently going out of his way to let the other team score. It was because of him being under pressure and him just being bad, a bad athlete. That is it. And the other things which took place also was due to under pressure. And this was not a performance error, but rather Mr. Fortuna just breaking under pressure. Lastly, I understand that I have elapsed my time, Madam President. If I could direct the panel to any more answers or could.
Sorry, can I
Answer.
just ask one
Yes, Madam
final
Arbitrator.
question? Sorry if I missed it, but so what is the actual applicable test for manipulation? Or is there no clear standard?
There's no clear standard, Madam Arbitrator. The manipulation itself, as we see in Article 20 of the Manipulation Football Matches and Competition, it is clearly stated in the 4 subsections that anyone who directly or indirectly by an act or an omission or unlawfully influences or manipulates the course of the match or also conspires shall be sanctioned for minimal 5 years or and will be stopped from taking part in football competitions. So the disciplinary code itself is the benchmark to decide whether who has manipulated and who has not manipulated the match. There is no actual test out there.
Just one more clarification question.
Yes, madam.
So in order to show match manipulation, can circumstantial evidence be used?
If circumstantial evidence be used, if it can be proven to the comfortable satisfaction. In this scenario, we don't see any evidence which incriminates my client, Mr. Fortuna, that he manipulated the match. We are now, if we were to see these two different pictures from a different point of view, we see Mr. Fortuna's father is doing one thing, which could not be related to him manipulating the match. Secondly, Mr. Fortuna is just under pressure and he is a bad athlete. So we cannot be putting both these pictures together and try to create a circumstantial evidence because they don't go well together. Mr. Fortuna has mentioned also in the record that he did not know what his father was up to. all he was doing was making sure that he performs and tries his best to compete for the nation. And he also was sick. And he mentioned to the team doctor that he might not be able to compete, but he still soldiered through. This says a lot about his character and his will to represent his country on an international level. If there are no further questions, Madam President and Madam Arbitrator, I would like to wrap up my submission over here. Thank you.
Before I begin, can I confirm that the members of the panel can hear me clearly and see me clearly?
Yeah.
Yes.
If I may begin. Good morning, members of the panel. My name is Seah, and together with my co-counsel, Mr. Ramesh Kanna, we appear on behalf of the Respondent, the Federation de International Football Association, FIFA. I'll be addressing the first two issues for 10 minutes, namely whether the statement of appeal is admissible, and thereafter, whether the appellant's refusal in handing over his mobile phone was considered lawful, and the legal consequences that may ensue. My co-counsel, Mr. Kanna, will address the remaining two issues on appeal for 10 minutes, and we respectfully reserve 1 minute for a rebuttal. Members of the panel, while the appellant seeks to rely on fairness to govern today's proceedings, the panel must keep in mind that certainty must be kept in balance. This panel has to simply decide whether an appeal filed outside mandatory time limits can proceed, to which the answer is no. Furthermore, the appellant's claim of self-incrimination does not override the need to protect the integrity of sport. He was lawfully required to cooperate in a serious integrity investigation and, despite being informed of the consequences, refused. Such refusal is unjustifiable where cooperation is essential to the fact-finding process, as noted by Madam President earlier. The respondent therefore submits that the appeal is admissible and the appellant breached the duty to cooperate. Turning to the first issue, we submit that a statement of appeal filed by the appellant is inadmissible for three reasons. Firstly, the appellant had failed to meet the deadline of 23rd April to file the statement of appeal. Secondly, reinstatement of the statement of appeal should not be granted as the appellant had failed to act promptly. And thirdly, in any event, the appellant had missed the deadline to file the appeal brief. Turning to our first argument, we agree with the appellant that Article 50, subsection 1 of the FIFA statute is applicable to today's proceedings, and we also agree that the appellant has only need to file the statement of appeal where he receives the full grounds. However, in light of all of these concessions, the appellant has still missed the deadline to file the statement of appeal. If I may turn the panel's attention to page 5, para 29 of the record. If the panel is with me, the CAS office had yet to acknowledge the receipt of the email and register the appeal, and clearly stated in unequivocal terms that they never received the email on the 28th of April. And as early queried by Madam President, she had asked whether the CAS has to receive the email, to which the answer is yes. By operation of R31 of the CAS Code, specifically for electronic filings of statement of appeals, the filing is only valid upon receipt of the electronic mail by the CAS Court Office. This is further clarified by the 2022 CAS decision of Hungarian Football Association and FIFA, which held that such emails must enter into the sphere of control of the appellant, which in our case did not happen. Therefore, the appellant has failed to meet the deadline for filing the statement of appeal.
Can I check? But this filing, she did file it on 2345, right? On the date that was required. It's just that there was some technical errors, right?
Yes, Madam President, and it brings me directly to my next submission as to whether the CAS can reinstate the statement of appeal in light of these technical difficulties. However, CAS jurisprudence and Swiss law generally notes that a remedy of reinstatement should not be easily granted, and there's a very, very high threshold. This was noted in a 2016 Swiss Federal Tribunal case of claimant and FIFA, where the court found that procedural formalities ensure that procedure complies with the principle of equal treatment of the parties. And this is further supported by the 2019 CAS decision of PFC and UEFA, which noted that a grant of reinstatement does not outweigh the legal security that must be afforded in legal procedure. And even if the panel today might consider reinstatement as a possible remedy, it should not be given, as the requirement for reinstatement is that it must be asked for promptly. And this was noted in a 2024 CAS case of FC Football Club and Galastray. And promptness in that case was noted to be a key criteria for reinstatement. However, in our case, it was not adhered to. If I could refer to
sorry, counsel, it's because the appellant's legal team did not know that CAS did not receive it, right? As seen for the reinstatement request.
Yes, Madam President, but we are saying that despite knowing that they had a legal issue on the on the 26th of April, if I may direct the panel's attention to page 52, the PDF page 52, Exhibit 9, which shows the WhatsApp message between the appellant and his IT counsel. If the panel is with me.
Yes.
It clearly states above that this text chain occurred on the April 26, 2026. And despite knowing that such a cyber attack had occurred, they decided not to take any preemptive action to check with CAS as to whether their statement of appeal had actually been filed. Rather, they waited until the 28th of April. And notably, promptness is a key criteria in requesting for reinstatement, and is therefore our submission.
So what is considered prompt in case law? Is it a few days or a few hours?
In a case law that I have cited, they noted that the appellant had failed to meet the criteria because they did not request for reinstatement in 40 days, which I do understand is a very long period of time. And promptness wasn't defined in that case, nor has it been defined in any other cases, but it's noted to be a general criteria. But if we construe promptness as to when they realize that they need to request reinstatement, it should be the 26th itself. And giving leeway that 26 is on a Sunday, if we follow the calendar date, they should have requested it on the next day, which is the next working day on the Monday 27th. And yet, the only day that they checked with CAS was on the 28th.
I mean, that's perhaps because they thought that there was a chance the email did go out. They were giving CAS one more day to get back to them to see whether they got the email. I would say that 2 days is not entirely tardy of them.
Yeah, I would say it's quite prompt.
Yeah.
I understand, Madam President, but we have to consider how much leeway is this panel allowed to give. And I note that I only have 3 minutes. I will quickly wrap up on my submission and turn to my second issue. Once the deadline has expired, it cannot be revived by reference to proportionality, absent an express provision in the code permitting such discretion. And we would submit that if we allow the CAS panel today to determine what amounts to promptness, and if they do allow that 2 days to be considered as maybe considered prompt, then what will be the threshold? Could 3 days be considered prompt? Could 4 days be considered prompt? You'll be setting a precedent that the CAS panel is unable to concretely decide when a prompt reinstatement has been issued. And we argue that this could be problematic for further cases, and we should be construing it to the moment that they realize that they had a technical issue. And I will turn now to my second submission regarding the submission of the handphone. We have 3 arguments. Firstly, the non-negotiable duty to collaborate has been breached. And this is following Article 12 of the FIDA Disciplinary Code, where persons subject to this code shall help to, and in particular, provide any evidence as requested by FIFA. and this is an absolute duty as noted by the 2022 FIFA appeal decision of Chilean Football Association. And in our case, this duty has been breached. If I may turn the panel's attention to page 4, paragraph 20 of the record. If the panel is with me, Mr. Fortuna immediately refused to cooperate when FIFA's representative requested that the appellant submit his mobile phone for FIFA's investigation. And as seen from the following paragraph, the refusal was sustained despite multiple requests, a clear violation of Article 12 of the FDC. And on this note, we agree that Article 6 of the ECHR may be applicable in today's proceedings. However, the threshold to apply Article 6, specifically the privilege against self-incrimination, is extremely high. And this was noted in a 2017 case decision of Jerome Velt and FIFA, where the only situation where this privilege might extend to private investigation is where there's a clear and imminent danger that privilege against self-incrimination will be circumvented. And they noted that the only case where this will arise is where there's evidence of collaboration between the sporting organization and the public authorities in which both parties would share information which may prejudice Mr. Fortuna's protection against self-incrimination.
Sorry,
However,
Counsel, I'm also interested in Article 8, which is on privacy, right? So,
yeah.
um, surely the duty to cooperate is not absolute, and it doesn't extend to every single communication, right? Especially when it infringes on privacy.
Yes, Madam President, it doesn't reach out to every single communication. However, Madam President, I know that my time has elapsed. If I may answer your question and briefly wrap up my submissions.
Sure.
We will argue that to invoke Article 8 just because of privacy claims will be detrimental to the fact-finding of sport in terms of investigations. If any sporting individual can simply claim that, hey, I do not want my mobile records to be out there because I'm afraid that my right to privacy would be endangered, then this will be a very bad precedent to set to allow other athletes to similarly claim that their fear of their information being leaked is considered to be a valid justification for them not to cooperate in investigations. This will be detrimental to the fact-finding process. And to conclude, we argue that a failure to hand over his mobile phone could be used for adverse inference. And this is supported by the IBA rules at Article 9, subsection 7, where the tribunal may draw adverse inferences that are adverse to the defaulting party in cases of their failure to produce any other relevant evidence. And it's rightfully queried by Madam Arbitrator. If the appellant had nothing to hide, then why is he refusing to hand over his mobile phone? And unless I may be of further assistance on the first two issues, this concludes my submissions. I'll now hand over my time to my co-counsel, Mr. Ramesh Kanna, who will address the remaining two issues on appeal. Thank you.
Before I begin, is the tribunal able to hear me?
Yes, we can.
Good evening, members of the tribunal. My name is Ramesh Kanna and I act for the respondent FIFA. I have two submissions to make. Firstly, the anonymous witness statement and the anonymous email are admissible. Secondly, Article 20 of the FIFA Disciplinary Code has indeed been breached. Now, with regard to my first submission, I make it on three grounds. Firstly, there is good reason for non-attendance. Secondly, the evidence is not sole nor decisive. And thirdly, there are counterbalancing factors that safeguard fair assessment of reliability. Now, I begin my submissions with the understanding that the opposing counsel had referred to the case of Keramuddin and had stated that the safeguards in that particular case are not present here, and therefore there is no fairness. Now, this legal position is misguided because the four safeguards in Keramuddin actually stem from these three elements that I have stated out, because these three elements originate from the ECTHR Article 6 guide. And why the ECTHR Article 6 guide is relevant is because this tribunal is seated in Switzerland, and therefore all judgments made by the CAS panel are subject to potential annulment by the STF, the Swiss Federal Tribunal. And the Swiss Federal Tribunal routinely uses Article 6 of the ECHR to understand what fairness and equal treatment mean in such proceedings. Now, thus going on to the first element. In the case that opposing counsel himself cites, which is the 2019 CAS decision of Karam Karamuddin and FIFA, the panel does not require proof of concrete threats or past violence. Now, I make this proposition with the cognizance that opposing counsel had stated in this particular case, a co-witness had been able to attain asylum, and that this is distinguishable from the present case. However, in Karamuddin, the CAS accepted anonymity not only because of this one factor, but because allegations went beyond spotting misconduct and engaged serious criminal conduct exercised by a powerful individual in a context where the witness was vulnerable. And CAS held that this criminal environment and power asymmetry objectively heightened the risk of reprisal, even without proof of specific threats. Now, the same...
So does that mean that so long as there has been rumors of a criminal organization, that is already sufficient to cross the threshold that you are speaking of?
No, Madam President, but I understand your concern. In this particular case, the fact that there was a criminal context is one structural factor. There was also power asymmetry. And the criminal context is not only supported by rumors, but there is actually an ongoing criminal investigation against the appellant's father. Thus, the fact that there is a third party that objectively determines that there is enough sufficient evidence to pursue a criminal proceeding against this particular individual, the threshold would be slightly above the hypothetical scenario that you would have stated.
Okay.
Moreover, with regard to the power asymmetry, it is also to be noted that the appellant's father is a very successful business person. Thus, the same structural features that appeared in Karamuddin do appear here. With regard to the second element, we are not trying to rely on the anonymous witness statement or the email alone to form the inference of guilt in the next issue. As Madam President herself had observed earlier, there are a lot of coincidences in the facts that go beyond these two pieces of evidence, such as the objective spotting evidence and the betting patterns and the performance of the appellant. Now, with regard to the third element, it is to be noted that all the procedural safeguards that the opposing counsel had stated, which is the fact that there is audio-visual blockage and interviews being conducted, all of that would fall within this element of whether there are sufficient procedural safeguards to forego cross-examination. And in Karamuddin, the CAS accepted reliance on anonymous witness statements despite the absence of direct cross-examination because the statements were indirectly tested through procedural safeguards such as internal consistency. Now, consistency was a key testing mechanism in Karamuddin. The panel assessed whether the anonymous statements were coherent, whether they acknowledged their own limitations, and whether they avoided exaggeration. In particular, the witness described what they personally experienced and did not claim knowledge beyond their direct observations. This is directly analogous to our present case because the witness regarding the anonymous witness statement recounts a specific contemporaneous observation, a stressed phone call the night before the match, while expressly acknowledging the limits of what they could hear or know. As in Karamuddin, the witness does not speculate about betting or criminal arrangements, but confines the account to what was personally observed. That internal restraint is precisely the type of feature CAS treats as a reliability indicator. And the email does not claim that the crypto transfers were payments for fixing, nor does it claim that Mr. Antonio agreed to manipulate the match, or that the sender knows the precise purpose of the transfers. Instead, it presents specific factual allegations and leaves the interpretation to investigators.
But he does say that I believe these transfers could be related to Iridonia's terrible performance. That is opinion, isn't it?
I understand, Madam President, but he is transparent with the fact that it is an opinion. He does not assert that it is indeed related. Moreover, in Karamuddin, it also held that there was another decisive counterbalancing safeguard was the corroboration by independent objective evidence. The panel relied on the fact that anonymous statements aligned with external material and did not stand alone or determine the outcome. Now, this is the present case. I shall explain this further with regard to the second issue, if members of the tribunal have no further questions regarding the first issue. Okay. With regard to Article 20 of the FDC, there are 4 elements to be proven. Firstly, there must be an act or omission by the appellant. Secondly, this act or omission must indeed cause a turn of events that determine an outcome. Thirdly, the appellant must be directly or indirectly connected to the manipulation. And fourthly, there must indeed be a conspiracy or an attempted conspiracy. Now, out of these 4 elements, the disputed elements are the third and fourth, which is whether the appellant was indeed directly or indirectly involved and whether there was an actual conspiracy or an attempted one. With regard to the third element, opposing counsel had stated that Mr. Fortuna never placed bets or communicated with the syndicate. However, in the case of Pobeda, the 2009 decision of FK Pobeda and FIFA, it had been stated that connection need not be direct. It can be indirect. An indirect connection here refers to a third party accruing the benefits of that manipulation. Now, the tribunal may wonder what is the nexus of connection that is then required. The threshold for the nexus of connection is considerably low because in cases such as Orikov and Pobeda, so long as the wrongdoer communicates with the appellant through an intermediary that the appellant trusts, then this nexus of connection is achieved. Now, in this case, the wrongdoer that is connected with the syndicate would be Mr. Fortuna's father. And given the familial relationship and the fact that the threshold of trust and influence is met, this threshold of sufficient connection is met. Moving on to the fourth element of whether there was a conspiracy. We do agree that, as the opposing counsel claims, these mistakes that were made by the appellant could be honest mistakes. And that is exactly why the CAS jurisprudence aligns with the fact that performance errors should not solely determine guilt. What is key here is not whether the error in itself was egregious, but rather the timing of the error was egregious. Now, if we refer to the facts, it is at the 20th minute that market suspended. And right before the market suspended was when the first goal was conceded by the appellant. Why this matters is because the first goal determines the dynamics of the match. And bookmakers suspend markets when they suspect that there is a non-random event that causes particular outcomes in the match. Moreover, it is not solely based on the fact that the bookmakers suspended the markets that we argue this, because as Madam President had earlier noted, even prior to the suspension of the markets, the betting was against Iridonia despite the fact that Iridonia was actually dominating the match. Thus, even before any goals were conceded, it is anomalous that Cometland, despite the fact that they did not have possession nor were they winning, was strongly supported by the bettors. Now, I understand that my time has elapsed. If the tribunal could accord me 1 minute to sum up my submissions.
Yep.
Thus,
I
in
think
short,
you're still not answering the most pressing concern, which is how, like, sure, the markets were off, right? But how can we relate that to him? How do you show that he really did conspire or there was some intention, right? Because I'm assuming there is an element of intention.
Yeah, as your opposing counsel has noted, it could well be that the anonymous evidence that you're relying on, like heavily, could be taken out of context. Thus, the appellant could have been ill, or he could just be a less skillful of a player. So how could it be that how do you concretely say that he did match fix?
understand, Madam President. With regard to proving intention, firstly, to answer Madam Arbitrator's question, intent is not an explicit element that is considered within the CAS jurisprudence. Instead, how the CAS panels in precedent cases have determined whether there has been a conspiracy or an attempted conspiracy is to understand if all the factors taken into account, do they converge such that the comfortable satisfaction standard is met? Now, I note that the tribunal had previously questioned opposing counsel on what the comfortable satisfaction standard is. And in Pobeda, the panel explains that comfortable satisfaction is met when the panel is comfortably satisfied that there is no reasonable alternative explanation that can be given in the face of the facts. Now, this also brings me to explain that despite all of these pieces of evidence we rely on being circumstantial, it is still possible to make an inference of guilt, so long as there's no possible alternative explanation. Now, if we were to look at just the performance of the appellant alone, opposing counsel's argument that it could have been fatigue or it could have been just incompetence would stand. However, what's to be noted here is that it is corroborated by the fact that right at the moment that appellant chooses to concede the first goal, there is a suspension of markets. And right before this, prior to this, during the 20 minutes the match has run, there's heavy betting against Iridonia, despite the fact that Iridonia is having the upper hand in the game. Now, these are two anomalies that are external to the appellant's playing. Thus, we would argue that all the pieces of evidence converge to only one possible theory that the panel could conclude.
Is it really all the pieces of evidence? Because how I understand it is, opposing counsel also pointed out that Fortuna said he was not feeling well. And then also at page 8 of the performance analysis, he actually saved a goal, right?
Indeed, Madam Arbitrator. So I'll answer the first question with regard to fatigue. We do understand that the appellant had made claims that would potentially go against this. However, the overarching evidential mosaic that we have in place supports the theory that the respondents run rather than the appellant's sole statement that they were fatigued. Moreover, we would also like to bring to the tribunal's attention that the appellant has not provided any form of explanation or rebuttal to the claims of the witness statement, despite opposing counsel claiming that it is out of context and it's questioning its reliability. This goes on further to show that there exists little basis for any alternative explanations that opposing counsel may run. Does the tribunal have any further questions?
No.
No.
Then I shall conclude my submissions.
Thank you.
Thank you.
Good evening, Madam Arbitrator and Madam President. Am I audible?
Yes, you are.
So I will be making the rebuttal in just one point. I would like to talk about the Genius report itself. The Genius report does not attribute the loss to Mr. Fortuna as recorded in the performance analysis. The goal at the goal section, it is stated that Mr. Fortuna actually was expressly saving. He saved the goal on page 8, and at 64 minutes, he expressly states that the second goal involved no individual error. And at 88 minutes, 13 seconds, the third goal resulted from a teammate's hamstring injury, which the report again confirms was not a performance error. I would like to shine light on the fact that Mr. Fortuna was a replacement. He was not the national goalkeeping athlete in the team, but he was replacing the national athlete who was representing FIFA at the FIFA competition. It is also to be noted that he was not feeling well at that day and at that point in time, but he managed to pull through and decided to compete in the competition anyway. And we also have to take into consideration that he was just not up to the standard to compete in the FIFA competition itself. Now, as to why he ended up competing, we have no idea, or we do not know how the Iridonian Federation works. But all we know is that Mr. Fortuna was not eligible and he was not skilled enough to compete in a FIFA competition. That will be all for my submission, Madam President and Madam Arbitrator. Thank you.
If I may begin.
Yes.
I shall answer the opposing counsel's rebuttal in 2 points. Firstly, opposing counsel had pointed to certain facts showing great performance on the appellant's part. Now, this particular defense would hold water if we were to assume that the appellant's performance throughout the entire match is necessary for the manipulation to occur. However, in real life, betting manipulation, the fruits of that particular manipulation can be achieved within the first 20 minutes when the first goal is made. Because Asian handicap markets and pull-in line markets allow for strong gains just through one goal or less. Thus, even if the appellant had been playing properly after the 20th minutes, all the gains that the appellant had to make would have been made within the first 20 minutes. Now, to rebut the second part of opposing counsel's argument, which is that it could just be player incompetence, I restate my point in that it's the convergence of all the evidence that's in front of us that the respondent relies on to make its argument, not the sole fact that there was poor performance on the appellant's part. I conclude my rebuttals.
Yeah, you can ask them come in here to